NBC 10 News has the latest on the retrial of Karen Read.
Walk us through the typical day for the jury and everybody else that's involved in the retrial.
Sure. So court starts at 9. Karen Read will arrive a little before that, around 8:45. Usually all the media is outside getting ready for her arrival. The prosecutors, the defense, they'll all arrive, go up the courthouse steps. And then court usually starts around 9. Sometimes it's a little bit later, 9:15-ish. The jury will come in, and sometimes there is something that the judge needs to discuss with the lawyers before they come in, so that possibly it could happen. And then once the jury comes in, the judge will ask them a couple questions, making sure they didn't see, hear, read about the case, talk about the case. And then once that happens, testimony will start. So a witness will be called, they'll come in the courtroom. Sometimes it's a witness who already testified the day before and they're coming back. So they'll testify, and then testimony will go on for a couple hours in the morning. There's a morning break, about 20 minutes, so the jury will get to take a little bit of a break, and so will the lawyers. And then the lawyers and the jury will come back in for more testimony. There is an afternoon break. That's a lunch break, and that's around an hour, 45 minutes. And then after that, the jury will come back in, more testimony. Things usually wrap up around between 3:30, 4. Usually it doesn't go any later than 4. But sometimes there are some sidebars during all the testimony. Sometimes they might have to argue something without the jury present. There are extended breaks that do happen sometimes as well. But usually the process is pretty much the same every single day. And then at the end of the day, Karen Read will come outside the courthouse with her attorneys. And sometimes she'll speak on the courthouse steps, on the bottom of the steps. Sometimes she won't. And that's kind of how the day goes.
One big change with the retrial is that the lawyers are under a gag order, meaning they can't talk outside of court. That does not, however, apply to Karen Read. Some days she's very talkative, other days she doesn't want to comment. What has been your impression of Karen on the days she is speaking outside of court?
I think it kind of depends. It comes in waves. It seems like for 2 or 3 days she won't have any comment, and then for a few days in a row she's really talkative. When things seem to be going the defense's way, or there's a witness that didn't really testify well for the prosecution, she seems to be a little bit more talkative.
One big question is, will Karen Read take the stand in the retrial? What's the buzz up in Dedham around the courthouse about this?
A lot of times when she comes outside of court, we'll try to ask her, hey, are you going to testify? And she says, not sure yet. I personally don't think she'll take the stand. I think reporters as well around the courthouse don't think so either. But again, these clips are being played this trial and the retrial. So the jury is still hearing from her in some way. So it's possible that because of this change, she might take the stand to kind of combat those clips and the things that she's saying, because obviously the prosecution is going to play clips that don't make her look very good.
Part of the elements that the Commonwealth has to prove is what we call a consciousness of guilt, right? A lot of these elements are going to require the jury to step into the mind of Karen Read and whether she intended to cause these bodily harms or not. And it's very early right now, but I would, put a lot of money down that she's not going to take the stand. So how else do you enter her mind but for playing clips that they've been playing in between witnesses, and also reading the text messages showing that there's a supposed wedge between her and John O'Keefe at the time, that somehow points to her consciousness of guilt.
As a general proposition, I would always advise my clients not to, or encourage them not to. It opens her up to cross-examination, and some more bad things could come from it. However, you do have these clips of her going out into the media where she's talking to the media, making some statements. And one day as she exited the courthouse, she said, well, we'll put those all in context. Was she hinting that she's going to get up there and put them in context? I don't know. But it will be very interesting if she gets up.
I don't think there's any way in the world she will take the stand. I think it's almost a few things you can guarantee in this world, but that's close to it. I don't see how it can really help it. Because it's easy for her to testify, but then cross-examination, they could go on after her for days and days, and it's a wild card, and I don't think that they need it. All the defense needs to do is to be able to say this case was not proved beyond a reasonable doubt. We haven't seen a smoking gun. We haven't seen anything that nails it. We see arguments on both sides that are rather strong. And again, like that old baseball phrase, tie goes to the runner. If the jury is kind of confused and not positive, there's battling experts and all that. And then that's not proof beyond a reasonable doubt, and you're not supposed to find you're guilty.
What differs about this trial from the many trials you've covered over the years?
A lot more complicated, a lot more detailed, and the defendant is allowed to speak when she comes and goes, but her lawyers can't. And that's a real risk. You could see the lawyers just hoping Karen doesn't say anything that's going to blow it for them, although she is so schooled in this case now that she's really almost acting like a paralegal. But the amount of detail, I mean, we just took a look at a list that they went down on glass that matched the taillight, that matched this and that, timing of satellites. It's a lot for a jury to absorb and comprehend.
You have to be very, very careful not to use too much technocrat kind of language, and you have to kind of explain to the jury in layman's terms that the average person can understand, and that can be a tough thing for either somebody testifying or for a lawyer. You don't want to lose them at all. Sometimes a case really does you really do have to give this scientific technical information, but it's a real talent and art how to do it without putting them to sleep, and without and doing it in some way that they can actually follow and make sense to them, and that's not easy to pull off.
There's a lot of information coming at them from pieces of evidence, numbers, technology, different clocks, different variances amongst the clocks. It's extremely confusing, and that makes closing arguments incredibly important, because they're going to be looking to the attorneys to explain what this evidence meant and show them why they believe it either proves Karen Reed's guilt or innocence.
Katie, what's different about the retrial compared to the first trial of Karen Reed?
The witness order is a lot different this time around. We haven't heard from some of the big key witnesses in this case. Brian Higgins, Brian Albert, they all testified the first time, but not this time so far. They still could be called by the defense, but they haven't testified, and the order's been a lot different. Also, these clips in court, Karen Reed did a lot of interviews, so they're being played for the jury to see. So even if she doesn't testify, they're still hearing from her in a way, and these are recent interviews she's done.
We're 5 weeks in. What's the most unique thing that stands out about the retrial for me? Right off the bat, the fact that there was a chaotic scene playing out on the lawn with a dead body, people screaming back and forth, Karen allegedly yelling, I hit him, or did I hit him, police lights blinking, a commotion, and yet the people who own the house either sleep through it, weren't awoken, and never come out. It's an odd one, isn't it?
Of the witnesses who have testified for the prosecution, who stands out the most in this retrial?
I think Shannon Burgess stands out the most, because he was a new witness in this case, and there was a lot of questions asked by the defense about his education, a lot of back and forth about whether he was lying about his resume or not on the stand. Also, I think Peggy O'Keefe, when she testified, she didn't testify the first time around. She was a really emotional witness, and that's something the jury got to see this time. She was crying on the stand, had a tissue in her hands. So hearing from the victim's mother, I think, was powerful in the courtroom.
What do you make of the prosecution's case so far?
Listen, they're doing the best they can, but they've got an Achilles heel. The lead investigator can't be called. And the guy who's sort of taking the place of lead investigator, the substitute, Sergeant Buchanan, he's damaged goods because he was punished in the first trial too. So they're doing the best they can. But you have to wonder if they are doing the best they can with that data witness who was called just this week, the guy who's trying to piece together the timing in the SUV's black box and the SUV and the clock in John O'Keefe's telephone. Turns out his resume was trumped up, his LinkedIn page is wrong, and he's been studying for a bachelor's degree for 17 years.
Sir, do you recall when you started pursuing a Bachelor of Science degree of any kind?
Sure, I do, around 2008.
If I did the math correctly, sir, you've been pursuing a Bachelor of Science degree for 17 years, correct?
That is correct.
And you have not obtained it as you sit here today?
That is correct.
And yet there are the various documents that we've seen that state that you have obtained the Bachelor of Science, correct?
Again, with errors or misinterpretation, yes.
Errors or misinterpretation that are you stating, but you would agree those errors or misinterpretation have been in existence for some time, correct?
Yes, I'm being made aware of them now, yes.
Yeah, and they haven't been corrected for some time, correct?
Correct.
One point that I would just kind of point out as a defense attorney that really made me cringe was the email communication where he admitted that he just copied and pasted from a prior email as to whether or not he did this investigation on his own mid-trial, or whether or not it was instructed by the Commonwealth to do this further supplemental report. And that I feel like was a really damaging piece of testimony.
You said on direct examination, sir, that you prepared your May 8th report on your own. Those were your words on your direct testimony, correct?
Correct.
I'm going to read the first line of your May 8th, 2025 report.
Okay.
Do you have it in front of you, sir?
I do, yes.
It starts, Dear Mr. Brennan. Do you see that?
Yes, I do.
Pursuant to your request. That's a request you're referring to of Mr. Brennan, correct?
Correct.
I have completed an additional analysis concerning the above referenced matter. To formulate opinions, the following additional items were reviewed. This wasn't done on your initiative. You put in writing you did it at the request of Mr. Brennan. Which is it?
So that was on my own initiative. This is a holdover, so a copy and paste from my original report.
You're explaining the May 8th report in your language pursuant to your request as a cut and paste from a previous report?
Yes, I am.
18 jurors in the courtroom every day, 5 weeks into this retrial. What have you noticed when you've been in court? What are your observations of this jury?
A lot of the jurors take notes, but not all of them. There's been a couple I've noticed that don't really seem to take notes. Others seem to be looking at their notepad the whole time, really listening, taking notes. Some of the jurors make facial expressions. One in particular has made a lot of facial expressions, and the judge did have to tell the jury that you shouldn't be making any facial expressions and also not to talk to each other about the case.
What do you think is going through the minds of those 18 jurors 5 weeks into this retrial?
Well, it's hard to say. You know, they're not supposed to consume any outside media. They're not supposed to be consuming Twitter or X or Instagram or television or radio. Or you got to wonder if that's been the case. Or it's almost impossible to be shielded from this case. So you got to wonder if they have preconceived notions going in or early in, and is that changing or is it cemented? And you got to wonder if if a lot of this stuff is going over their head, because it's very complicated.
There have been a lot of sidebars happening during the retrial. What is the judge or what is anybody saying about the sidebars that are happening during this trial?
The judge will remind the jury when these sidebars happen that we're doing work at sidebar to try to streamline this process along, try to figure out things that are going on so there doesn't have to be more breaks. We can figure things out at sidebar instead of taking a break. So she's been telling the jury that a lot. I think she did last trial as well, but it seems like there has been a lot of sidebars this trial, and they last a few minutes, but basically they're working through them the whole time to figure out things for testimony, questions they might ask, lines of questioning.
There are different lawyers taking the lead in the retrial, both for the prosecution and the defense. Talk to me a little bit about the new people we're seeing in the retrial that are taking the lead on this.
Robert Alessi, he's new to the case. He has been handling a lot of the cross-examination of these witnesses. He's very energetic, asks a lot of questions. He makes a lot of facial expressions too. You can tell he kind of gets excited about something or his line of questioning. And I see these lawyers every day, inside, outside the courthouse. He's very cheerful. He always says hello. And then also Hank Brennan, he is a famous lawyer, has a very high reputation. So it's interesting to see him be a special prosecutor because he's been a defense attorney in the past. And he's another high caliber lawyer who's in the courtroom this time around.
Katie, describe the atmosphere outside the courthouse in Dedham.
Outside the courthouse, the atmosphere is so much different than it was the first time around. People, if you watch the documentaries, you see how intense it was outside the courthouse. In our reporting, you could see how intense it was with people in pink, people in blue, all dressed up, kind of tailgating on the sidewalk. And now with the buffer zone, it's not like that anymore. There's been some changes to the buffer zone as the trial has progressed, and now people can stand outside the courthouse as long as they're not holding signs, as long as they're not making noise. But the atmosphere has just really changed because the people, supporters of either side, have to be further away from the courthouse. So if they're wearing pink, if they have signs, they have to be pretty far away. And not as many people are showing up every single day, so it's definitely a lot different than it was the first time around, just the atmosphere outside.